Good afternoon. Thanks for your attention, everyone. The deadline for the implementation of the EU's 2019 Digital Single Market, or DSM directive, came and went on June 7th of this year. But in fact, it remains in varying states of implementation amongst its member nations. Recent yet delayed guidance from the European Commission on Article 17 of that directive, as well as some recent and pending judicial decisions, are impacting that process. So what exactly is going on and how is it playing out? What are the benefits to everyone if things go well? And what are the challenges that remain if they don't? Ted Shapiro heads up Brussels office for Wigan LLP, and before joining Wigan in 2013, he served as the general counsel for Europe for the Motion Picture Association, representing 7 international producers and distributors of filmed entertainment. In addition to assisting clients on issues relating to policy, litigation, compliance, and commercial transactions, he's widely recognized as a leading expert in international and European copyright law. And having had the pleasure of working with Ted at the MPA for almost 15 years, I can confirm that his knowledge of copyright law and its inner workings in the EU are second to none. We're thrilled to have him today as our featured guest. Ted, welcome. Thanks for taking the time to speak with us today.
Thanks very much, Frank. It's great to be here, and it's great to see you.
Ted, there seems to be a lot going on in the news across the European Union lately, maybe not right at the moment, in terms of IP harmonization. And before turning to substance, for those of us who don't live there, could you please address the general process of harmonization? Which IP laws fall within the European Commission's jurisdiction, and how and why are they typically considered as matters of policy?
Okay, well, yeah, so it's a very broad and general question, but it's a nice background to sort of very generally beyond IP to try and understand what is the European Union doing. And they're obviously doing a lot of things, trying mostly to make sure that they don't go to war against each other like they did in past centuries, but obviously much more to the point, and much more recently, they are trying to build a single market where people, goods, services, capital all move freely across borders without impediment. And that has been something that they've been trying to achieve and gradually achieving in the physical world. And really, lately, there's a parallel effort to do that in the digital sphere. So to build the digital single market. And a lot of that revolves around harmonizing national laws. And there are different tools for harmonization. The EU has different kinds of legislative instruments. The 2 main ones are directives, which are laws that are passed at the European level by the European co-legislator, which is the European Parliament, and the Council, which makes up the member states. The co-legislator passes laws that are proposed by the European Commission. And a directive then has to be transposed into national law. Usually there's a fair amount of leeway. The other big instrument that is used that also gets adopted by the European co-legislator is a regulation. And a regulation is directly effective. It doesn't need national implementing legislation. And we are seeing a trend toward more and more regulations being proposed than directives. We've even had our first regulation in the copyright sphere a few years ago, the portability regulation. When it comes more specifically to IP, the Commission identifies areas where national IP laws may be impeding free movement and proposes harmonization measures. And in some areas, the EU has very strong competence in intellectual property, particularly in the international sphere for treaties. They have exclusive competence. And when it comes to internal competence, under the EU treaty on the Treaty on the Functioning of the EU, they have quite a broad power, particularly when it comes to trademark and patents. We have seen EU regulations creating EU trademarks, for example. Now, we're far way away from a European copyright law. We still have national copyright laws, but we have seen a lot of legislation harmonizing national law, and over time, more and more uniformity there's a ways to go. It's not a European copyright law, but we have seen harmonization in a great deal of areas. And the 2019 DSM copyright directive is a recent example.
Okay, so within this framework of harmonization, how much discretion or authority do individual EU members have to go beyond these obligations that are set out in either the regulations or the directives? Are they free, for example, to adopt protections that go beyond and above these minimal norms?
So, yeah, it's a typical lawyer answer. Of course, it depends. As I mentioned, generally, directives give a fair amount of room for member states to implement as they see fit. But some measures in a directive, or sometimes the whole directive, may be construed as what is known as full harmonization, which means that member states don't have the same level of discretion and may not be able to go beyond what is in the directive. And they will have even less discretion because there's no national law implementing for a regulation. Now, in the copyright sphere, in some directives, we do have areas where member states are allowed to provide more protection, but there are also examples where they may not. So the scope of the communication to the public right in Article 3 of the 2001 Copyright Directive, member states are not allowed to go further than the exclusive right that is adopted at the European level as interpreted by the Court of Justice. Because if they did, that would have an impact on the functioning of the internal market. Now, you could have other areas where more protection is allowed. You can have stronger penalties and things like that for infringements, but the scope of the right is subject to full harmonization at EU level in that particular instance.
Okay, let me ask sort of a related question from the opposite way then. What mechanisms exist, if any EU members' laws as implemented fall particularly short of, say, these EU norms generally, or if one country thinks that another country's laws don't meet up to the minimum standards in the regulation in the norms?
So there is a mechanism. So first of all, the European Commission, the executive arm, if you will, of the EU, is charged not only with the right of initiative, proposing new laws, but also with enforcing EU law. And it has a number of measures at its disposal to ensure that member states correctly implement EU law. And there is a mechanism that actually takes place during implementation of a great deal of different directives where member states are meant to notify drafts so that the Commission and indeed other member states might be able to pre-identify problems and raise them. And sometimes that can lead to a request for standstill. Now, this is a difficult and complex system. Remember, we're talking about the EU is kind of like a system of pooling sovereignty. You throw a bunch of sovereignty into a general pot. You give up some freedom, but you get the benefit of this bigger market. Something that the UK, well, they didn't want that anymore. And now they've lost out on all those benefits, but they now have the freedom to do what they want. And so the EU isn't going to send in the tanks if you incorrectly implement a directive, because there are no EU tanks. But the Commission will start off after the law is adopted by identifying a problem, or there may be a complaint by a private party or another member state or another institution saying, look, this particular country has not implemented the law correctly or didn't implement the law. And the Commission will send letters to that country saying, hey, you're late, or you didn't do this correctly. In fact, there's a fair amount of late letters going out. And that usually leads to compliance. But of course, there may be a lot of reasons why member states are late. And of course, and sometimes do things incorrectly. And we've seen a lot of delay, obviously, due to COVID. And so if they're really late or they do something correctly and they won't remedy the problem, well, then the Commission can bring legal proceedings against them before the Court of Justice, and ultimately fines can be levied. This is something that happens very, very rarely, but it is a sanction that is in place. There are mechanisms Perhaps they don't have the sharpest teeth in the world, but there are mechanisms for the European Commission to ensure compliance with EU law, with the ultimate arbiter of that question being the European Court of Justice. And there are huge incentives for member states to comply, but certainly there are issues.
Okay, thanks for that very diplomatic answer. Ted, in your experience, let's stick with copyright protection and enforcement just for the moment. In your experience, are certain EU members maybe ahead of the curve in terms of protection? I heard what you said about if you get too far ahead of the curve, it disrupts the harmonization. But are there best in class or problem children another way around within the 27 members of the EU?
Well, there are certainly, and you've seen this in Asia, a region, of course, that much better. There's certainly countries that are more pro copyright than others. And why is a given country pro copyright versus being anti copyright? Well, that a lot depends on what that country is strong at. And so a very pro copyright country in Europe, perhaps the leader of the pack, if you will, is France. And that is because France has a very strong content industry and feels that it has a lot to defend. It feels that it is the natural leader for copyright in the European Union. And they are usually the most pro-copyright, pro-author country in the European Union. Usually in that pack, you have Italy, although there was a couple of aberrations recently. You usually have Italy, usually have Spain, usually have Portugal, Greece, so what they call Club Med in that area. And then on the more anti-copyright side of the equation, you tend to see the Nordics, with the Germans and the Danes being more in the middle, I guess. And so, where does that leave us? It means that we normally get very good implementations of directives, sometimes going beyond, if possible, from the French. But it's interesting because the Danes, which are a relatively pro-copyright country, but are known as Eurosceptics, are always on time implementing their laws and normally do it generally faithfully. Although there are some questions around certain things they have done with regard to something called extended collective licensing and SVOD services recently. But that, I think, is a fair thing, that it's sort of France, Spain, Italy are the big pro. Germany, middle or not so pro, and Scandinavian countries, the Dutch, being less pro, verging on anti-copyright in their approaches, in the positions they take during the negotiations for the legislation, and then in their manners of transposing it into national laws.
You had mentioned Brexit earlier, and I sort of wanted to put a pin on that and come back to it later. But my recollection is that the UK was among the leading proponents of site blocking, for example, as a means for enforcement. Whereas I recall Hadopi, the French approach, never really got off the grounds or never really achieved the results that had been hoped. Had the UK, let me, I guess, get back into it. If the UK were still in there, where would you rate them?
So they are a pretty pro-copyright country, but not perhaps not as pro-copyright as France. And that on the basis, they have a very good Copyright Act, but that on the basis of the positions that the UK government took in Brussels on pleadings they have made to the Court of Justice that might have fell short of what I would have called very certainly the French position. Now, you're absolutely right that the UK has a strong site blocking regime in place from Section 97 of the UK Copyright Act. Section 97A, sorry. But Section 97A is the UK implementation of Article 8.3 of the 2001 Copyright Directive. And as a technical legal matter, the French implementation of Article 8.3A is better. It's Article 8.3 on, sorry, not 8.3A, but Article 8.3. It's Article 8.3 on steroids. It's a broader interpretation, and it's one that was permissible under the directive. It didn't go to the defining a scope of a right, but actually the scope of a remedy. And it's a broader remedy than what was required by the directive, perhaps. And although you saw site blocking cases in the UK, I believe before we got them in France, it's well established in French law now. Perhaps a big difference is the scope of the orders. You get a much more dynamic site blocking order in the UK than you can get in France, although there's legislation in that regard, newer legislation in that regard in France at the moment. And Article 8.3 is pretty well implemented across the member states, but there again, there are some aberrations. The polls haven't implemented Article 8.3. And the Commission hasn't taken action against them. Of course, the Commission has taken multiple actions against Poland for other things. Going back to the more diplomatic points that I was making at the beginning of our discussion, and the polls, you were talking about what other member states might do. The polls have actually challenged part of Article 17 that you were referring before. They've actually brought the Council and the European Parliament to court, the Court of Justice, seeking to strike down parts of Article 17, which they believe is inconsistent with the freedom of expression under the Charter of Fundamental Rights of the EU.
That's a really good segue because I was getting around to asking you to turn into the substance a little bit of the DSM. Let's get right into Article 17. So Article 17 relates to the so-called value gap between revenues for platform operators operating copyrighted works to consumers and the remuneration paid by those platforms to the rights owners whose works have been used. Ted, could you give us just a brief background? What's behind that article and what was its intended purpose?
So, well, as you say, Article 17 was meant to address something called the value gap. And this is a perception that the money that was being earned, particularly by the music industry, and I think it's more than a perception, actually, that the money that was being earned by the music industry from sites like YouTube, and what YouTube was earning was significant. And you could say there's a value gap between what they earn on Spotify and YouTube, but also what YouTube earns versus what they were getting. But basically, the music industry felt that they were not getting what they should get from services like YouTube for the use of music. And the reason why was because YouTube had actually started to license music, which would allow their users to upload whatever they wanted. But they weren't paying what I think the music industry would have considered a fair price for it. And because they would say, well, look, we're actually not responsible for the music that's uploaded onto YouTube because of Article 14 of the e-commerce directive, the hosting privilege, similar to you have in the DMCA and other countries. We're not responsible for content that others upload onto our website. We don't know about that. We don't have specific knowledge. And it's only when you give us specific knowledge by a notice that we'll take that down. So if you're not happy with what we're willing to pay for that, well, send us a takedown notice. And of course, they built this system, Content ID, where you could decide to leave up the music and monetize. The problem was that the monetization was not sufficient for the music industry. And so they wanted the legislator to step in to bridge the value gap. And what Article 17 does is it removes that argument from YouTube. First of all, it clarifies that YouTube is engaged in copyright relevant acts. They communicate to the public. And second of all, it clarifies, confirms, some would say there's arguments about that, but it now states that YouTube does not reside in the hosting safe harbor. And as a consequence of that, if you communicate to the public and you're not in a safe harbor, you don't have a liability privilege, as a consequence of that, you need authorization or you need to do something about the infringing content on your service. And that has changed the dynamics, if you will. Now, What they've done, though, is they've said, okay, if you don't have authorization, you need to do something about that infringing content. If you do all of the things that we're requiring of you, you go into a new safe harbor. But on top of that, and this is where it got super controversial, how do you deal with non-infringing content that goes up onto YouTube? If I'm a rights owner and I send YouTube a data feed to my repertoire, so that they have, it's all watermarked and they know whenever my content goes up, and I say, I'm not licensing you any of this content. Anytime it comes up, you block it. But what if it comes up blocked? What if it comes up in a parody? So that content could probably benefit from the parody exception. So the question becomes, which comes first, the exception or the exclusive right? Now, copyright purists, traditional copyright law would say, well, exceptions are defenses to what are otherwise infringements. You get to say that I benefit from an exception when I come to you and say you infringe my copyright.
Right.
You don't get to use the exception to batter down the door. It's not a sword. Well,
No infringement, no exception.
Well, exactly. And so, but what we're having here is the other side of this argument saying, well, that means that non-infringing content is going to be blocked before it ever has a chance to get up there. And the directive has a provision that says that the cooperation between rights holders and platforms shall not prevent the incidence of non-infringing content. Now that creates an internal inconsistency in Article 17, and there's been a huge argument. Does that mean non-infringing comes before exclusive rights? So pro-copyright people would say the exclusive right comes first. And if you have a defense, so the content gets blocked. If you have an exception, you complain, and if you're right, the content goes back up. The other side says it's the other way around. And the commission's guidance has said that it's only if it's manifestly infringing can it be blocked in the first instance. And the Germans have created an even more complicated but similar type of thing. But those approaches put exceptions, those latter approaches put exceptions before exclusive rights, which is an anathema to copyright ayatollahs like myself, but is also maybe a bit more pragmatic about the way things work. The difficulty is that the French have a much less onerous, much more pro-copyright approach to Article 17 than the Germans do. So on two sides of the Rhine, we have different approaches. And so, it's a big question about how you comply with this stuff if you're operating a pan-European service. Likely, you'll make sure that your German service is in compliance with German law. You'll make sure that, but for .com, what do? Take the common denominator, follow the guidance. So those are things that people are struggling with now as we're seeing more and more member states implement. That said, we're and you referred to this before, Frank, we're way behind on implementation. We're way behind on implementation of the DSM copyright directive for several reasons. One, there's this thing called a pandemic. I don't know if you've noticed, but there's this global pandemic going on. That has, generally slowed down a few other things, as you may be aware. And so it's also impacted copyright legislation in the EU. And it's a complicated, controversial directive. And you alluded to this as well, the commission was meant to issue guidance on Article 17 and issued it like on the day of the day or a couple of days after the deadline for implementation. And as I mentioned, the Polish government has challenged parts of the directive. So member states are sitting there going, well, what to do? And so it's delayed. Now, the Germans have finished. The French have mostly finished. But they did Article 17 and a few other bits and pieces. The Danes have finished. The Dutch have finished. But a lot of other member states have a ways to go.
Oh.
And so this is coming into place as we speak. There'll be a few more, I think, in place before the end of the year, but people will still be implementing next year. Now, I've been around for a while, and I remember the 2001 directive. The last member state to implement the 2001 directive was in August 2006. So sometimes these things take time.
And so would we expect to see 23 and a half late letters going out at some point?
Some late letters have gone out apparently.
Okay.
I would have thought the commission was going to have more forbearance, and I think they have had a bit, but I believe some infringement letters have gone out. I thought I saw a report on that the other day.
Okay, so you just rattled off the ones who have finished: Germany, Denmark, Netherlands, and France, more or less.
Yeah, there's a couple others too, but I don't recall.
And so, I mean, so 2 years they were given to implement it, and you've said you saw in the case of the 2001 directive, the last one to come in was 5 year process.
Nearly 5, yeah.
So is this kind of what you guys in Europe would expect? Par for the course?
I mean, it's more or less par for the course. People are late in implementing legislation, and it's often funny. I was referring to this before. That sometimes the countries that you think of as bad Europeans, well, they're serious about their obligations. So, they may not like it when they fought over it, but once they agreed, they implement. And then then they're the ones that say yes, 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 and then afterwards they're late. And they're sometimes the more pro-Europeans. But this time the French have already implemented a lot. Not completely, but they've already implemented Article 17, so they were actually on time. The 2001 directive, the French were last. They were the ones that did it in August 2006. But the saga of the French implementation of the 2001 directive had lots of interesting plot turns. There was nearly a compulsory license for the internet adopted like a week before Christmas, and then everything got delayed. So there was a bunch of things that happened. It was subject to review by the Constitutional Court after it was finally adopted. So things were really delayed. But it ended up that the French implementation of the 2001 directive was a really good one.
I mean, in terms of the internet, 20 years ago sounds like forever. It really wasn't a terribly developed phenomenon at that point. I remember I was still in the music industry, and the music guys were hit harder simply because the bandwidth that was needed to transfer files, without obstruction was a lot less than the technology permitted for movies at the time. But man, 2001, you're right. It was wholly issues about, rights and wrongs and things almost of a theological level.
I mean, it's true, but the 2001 directive which implements, there's a big harmonization aspect of it, but it also implements the 1996 WIPO copyright treaties. And there's two basic tools in the 96 treaties and in the 2001 directive that I think are completely relevant today. And, I could have lived without the 2019 directive. I wouldn't have minded if they hadn't done it. Although the Court of Justice has clarified some things that make Article 17 look a little bit more attractive than before. But those tools from the 2001 directive were recognition of the so-called making available right, the on-demand interactive right. That's the key right that you license and enforce online. That's the right that is implicated, along with the reproduction right, but that is implicated by whenever you watch a video on demand or whenever you listen to a song on Spotify or whatever. And the legal protection of the DRM that allows all of that to happen. Those basic building blocks were in the 2001 directive and are still critically important to the way all the online services function now and the way that rights are enforced against unfair competitors. For me, the 2019 directive actually weakens a few elements of those things by creating more exceptions, by slightly weakening the legal protection of technological measures, by creating this notion that exceptions come before exclusive rights. Perhaps. I mean, it's still an argument, I suppose. And so on the other hand, a lot of people are saying, look, YouTube was in a safe harbor and they're not in it anymore, at least as copyright is concerned. So Article 17 is a step forward. That's going to be a debate, but since the Court of Justice has clarified in a older case that before the new law, YouTube didn't communicate to the public and YouTube was in the safe harbor, Article 17 looks more attractive than it did before that recent case.
I see. As a father of a musician, I might tend to agree on that one, or watch that a little bit closer.
Yep.
So look, getting back to an earlier question, then procedurally, June 7th came and went. A number of late letters probably went out. Give us an idea of what we can expect to see. What would generally happen next?
Member states will get on with implementing. There'll be a few very late ones, but we'll get a few more this year, and most member states will finish next year. And I don't know that it'll come to full legal proceedings, but what happens is, there may be a couple of judgments of the Court of Justice saying you're condemned for not implementing, and then they will. Fines are very, very unlikely.
Well, now you just mentioned the case pending in Poland, or brought by Poland, I should say. And the oral arguments weren't terribly long ago. I think like within the last 5 or 6 months.
Yeah, we will get a full decision in that probably end of this year or the beginning of next year. My prediction is that the Poles will lose, but that the court will probably lean towards the Commission's interpretation of Article 17, which, as I said, favors exceptions more than I think that they should. And that will also give member states more comfort about finalizing their implementations. We'll see, but that's my prediction.
And the gist of the Polish argument, if you will, is that there's a conflict, if you will, between Article 17 and a pre-existing freedom of expression or freedom of communication.
Yes, in the Charter of Fundamental Rights of the EU. What's interesting is that the Poles believe that the parts of Article 17 that require, so if you don't have authorization, you have to basically filter out the infringing content, and you also have to have a stay down provision for content that got through the filter and then was notified and taken down. It has to stay down. They believe that Article 14, 4B and C violate Article 10 of the Charter on freedom of expression, because non-infringing content could be filtered out. They disagree that the directive, so the French say the French say the exclusive right comes first, and if non-infringing content is blocked, that content can suffer a little bit of temporal discomfort, make a complaint because there's a dispute mechanism in Article 17, and the content comes back up. The Poles say non-infringing content should never be blocked, and they say that the Commission middle ground, if you will, about, well, there's this thing called manifestly infringing content. They say that's not in the French and the Poles agree that's not in the directive. They just agree that the outcome is the total opposite. But so they both think that the Commission is wrong. But the Poles are taking a very populist approach to this, and they are championing free speech in a manner that seems slightly going beyond the letter of what the directive actually says. I'm trying to be diplomatic here, but
yeah, I mean, whenever words like never come up, it's like saying it shall never rain. There's always got to be exceptions. And then, my goodness, this test that the Germans have proposed, manifestly infringing. Is there any guidance or discussion on the street of what that might mean?
So they've got a whole, it's much more complicated than that, Frank. I'm not, hopefully you'll have some German lawyers and other panels that will like to get into this, but they have created a red button that you can push also that will you'll be able to press, the right holder can press. And that means that it's manifestly infringing. So you can have things like early released films and things like that. They've also got some time limits on the amount of content that are in. It's a hugely complicated mechanism. The Germans really went to town on Article 17. They've also created remuneration rights for UGC content. So if you decide to monetize, authors and performers get money through their collecting societies. And so that's if you decide to monetize. You also get paid so I mentioned that there could be a parody. So the producer can't take down the content because it's covered by the parody exception. The authors and performers still get a remuneration for connected to the exception. Bit like you have remuneration rights in European laws connected with the private copy exception. So the Germans really went to town on their implementation of Article 17. They did it in a separate act to the Copyright Act, which they did so that they tried to say in a way that this was a sui generis thing, not connected to the communication to the public right in Article 3 of the directive. There was a huge battle in Germany over this. The German government had made promises about the way they would implement the directive that maybe were inconsistent with what the directive had said. But when it comes to your exact question about how the mechanism in Germany works, well, I can send you a 20-page memo on that. And obviously refer you to some more specialized German lawyers, of course, but it's incredible.
The thing about user-generated content, that term, I mean, it's one thing if it's your own content, but a lot of users tend to take other people's content and throw it up on YouTube for whatever reason and don't give it a second thought. And that's why I've always thought that term is a little bit loaded.
Yeah, well, you're absolutely right. I mean, the term for the platforms that are covered by Article 17 is online content sharing service providers, and they're not actually using the term user-generated content. They refer to content uploaded by users, and so that can be, as you say, either their own stuff, but maybe with their own thing, but maybe they put somebody else's music in the background, or it may just be a clip of a film that doesn't belong to them at all. But that's the easy one. If I have notified YouTube in advance of all my films in my repertoire, anytime, even under the German law, more than 90% of that film is uploaded, that's manifestly infringing. It gets complicated where it's a mashup, and that's where the Germans struggled, and that's why they created this incredibly complex way of doing it.
Well, the mashers thank the Germans, I guess, for looking out.
Well, there were demonstrations in the streets.
Really?
People, yeah. Well, the rhetoric always goes crazy, and that this thing was also going to break the internet. The German government had promised that they would ban upload filters, but they couldn't, because the only way to really comply with parts of Article 17 is through content recognition technologies. And they've been, they're getting better and better, but they still don't know the difference between an exception and an infringement. But they've been around. I mean, we had cases in the late 90s where the court ordered filtering. Mininova in the Netherlands was when they filtered out all the infringing content on Mininova, there was stamp collections left, and they went out of business.
I wish we had $1 for every time we'd heard that the internet was going to be broken somehow.
Yeah, site blocking was going to break it too. Yeah. I always say that I was on the internet just this morning. Yeah.
Before it broke. Ted, one last one. We sort of danced around before, but what's the effect of let's look back at England. What's the effect of Brexit on the EU jurisprudence insofar as IP protection or copyright protection is concerned? Is the UK now get a head off in its own direction, or is there value in maintaining some consistency with the rest of Europe?
So on day one of Brexit, the UK basically has EU copyright law and all its jurisprudence on its books. That's on day one. And then, of course, on day two, they could start to deviate. The US adopted English common law in 1780 something, and we slightly diverged over the centuries that followed, as you know. I think that there are some good reasons why they will want to stay where they stay relatively aligned, access to the market and all, but we will start to see deviations over time. I'm aware of so decisions of the Court of Justice are no longer binding on the UK courts, and there has already been litigation in the UK courts where the court has been invited. So this is with respect to Court of Appeal and higher. So I've already seen a big case that we were involved in involving for the music industry, where the Court of Appeal was invited by the defendants to ignore some Court of Justice jurisprudence on communication to the public, and they decided not to. But it will happen. It will happen. And, you know, it depends on the UK government as well. They will look at copyright reform. They didn't implement the 2019 directive, but there are calls for implementing some of it. And there are calls for copyright reform. And that's where we will start to see some deviations. But you know how that'll play out will play out over time, but it will come.
It sounds like it's going to be a minefield for lawyers, which I would think you guys, Wigan, is uniquely situated for with your offices.
We certainly are. We certainly are. And Brexit, well, you know, whenever you create these uncertainties, obviously the legal profession is well placed to benefit from that, at least in the short term.
Because it always depends.
Because it always depends. To close on that definite point.
I think that's a great point to bring it to a close. I thank you so much for such an enlightening background discussion. We got into so much detail, but such generality as well. I really covered a lot of ground. I wonder if we should open it up to questions now that the audience might have.
Sure, I'd be happy to answer any questions.